3, 2, 1, start. The word shall in Rule 109 within bracket 10 is qualified by the word endeavor. Stop. The mandatory nature of the word shall is also diluted by the phrase if the suit is not decided within the such period. Stop. The time period provided for deciding the suit for partition of holdings under section 116 of the Uttar Pradesh Revenue Code 2006 read with rules as provided in Rule 109 within bracket 10 of the Uttar Pradesh Revenue Code Rules 2016 is directory in nature. Stop. However, the requirement to record reasons for exceeding the timeline of 6 months is mandatory. Para. I had the occasion to consider the nature of the legislative mandate to the courts where directory provisions in a statute require the courts to render a final decision in a specified time frame in Tribhuvan Prasad versus Uttar Pradesh Sarkar and others reported at 2018 within bracket 9 ADJ 466. Stop. In Tribhuvan Prasad within bracket Supra, the time frame provided in the statute for deciding the appeal was 2 months. Para. In Tribhuvan Prasad within bracket Supra, it was found that the provision containing a time frame to decide the appeal was directory, and then the consequences of the said holding were construed on the foot of good authority. Stop. The directory nature of the provision may not require strict adherence but insists on substantial compliance. Stop. Most pertinently, it does not permit indefinite enlargement of the time fixed by the statute. Semicolon. Para. Statutes fixing timelines to accomplish an action as discussed above were held to be directory in nature. Stop. The legislative intent was sought to be defeated by a highly delayed compliance on the pretext of the provision being directory in nature. Stop. The action of the authorities was invalidated and such interpretation was negatived by the Honorable Supreme Court. Stop. Inordinate delay does not satisfy the requirement of substantial compliance of a directory provision. Stop. The Honorable Supreme Court in the case of State of Haryana versus PC Wadhwa IPS Inspector General of Police and another reported at within bracket 1986 the 2 SCC 602 while laying down the law dispelled all such doubts. Stop. The relevant parts of the judgment are being extracted for ease of reference. Para. The whole object of the making and communication of adverse remarks is to give to the officer concerned an opportunity to improve his performance, conduct, or character as the case may. Stop. The adverse remarks should not be understood in terms of punishment, but really it should be taken as an advice to the officer concerned so that he can act in accordance with the advice and improve his service career. Stop. The whole object of the making of adverse remarks would be lost if they are communicated to the officer concerned after an inordinate delay. Stop. In the instant case, it was communicated to the respondent after 27 months. Stop. It is true that the provisions of Rules 6, 6A and 7 are directory and not mandatory, but that does not mean that the directory provisions need not be complied with even substantially. Stop. Such provisions may not be complied with strictly and substantial compliance will be sufficient. Stop. But where compliance after an inordinate delay would be against the spirit and object of the directory provision, such compliance would not be substantial compliance. Stop. In the instant case, while the provisions of Rules 6, 6A and 7 require that everything including the communication of the adverse remarks should be completed within a period of 7 months, this period cannot be stretched to 27 months simply because these rules are directory without serving any purpose consistent with the spirit and objectives of these rules. Stop. We need not, however, dilate upon the question any more and consider whether, on the ground of inordinate and unreasonable delay, the adverse remarks against the respondent should be struck down or not, and suffice it to say that we do not approve of the inordinate delay made in communicating the adverse remarks to the respondent. Para. Thereafter, the duties of the court and the manner of implementation of a directory provision of law were laid down. Para. In case the appeal is decided within 2 months, the letter and spirit of the statute is implemented. Stop. However, mere failure to decide the appeal within 2 months does not violate the statutory mandate. Stop. In the latter case, the statutory obligation will be defined by the quality of the efforts made to decide the appeal with promptitude and dispatch. Stop. The obligation will be met if the appeal is decided within a reasonable time after the expiry of 2 months from its institution. Stop. Para. Statutes of limitation are statutes of repose. Stop. Statutes with timelines for decision making are statutes of endeavor. Stop. Statutory duty is discharged not only when the act is done but also when effort is made. Stop. However, the leeway to the authority is not unlimited and the time to accomplish the act is not indefinite. Stop. The statutory duty of the appellate authority in the event the appeal is not decided within 2 months is to be seen. Stop.